Now, last week we reported that former President Jacob Zuma had lost 2 attempts to appeal a dismissal of earlier attempts to privately prosecute 3 people. Journalist Karyn Maughan, the state prosecutor in his corruption case, Advocate Billy Downer, and then separately the President of South Africa. So also last week, the news that after numerous court battles and a parliamentary inquiry, the public protector had finally been impeached. But of course, Busisiwe Mkhwebane already indicating she plans to appeal that decision. Now, while we are all equal before the law, it seems if you're rich and powerful, or at least have the financial support and plenty of time, you can spin out a case as long as you like. Let's discuss this now with Narnia Bohler-Muller of the Human Sciences Research Council. Thank you so much for joining us. You've written a very interesting article with a colleague in the Conversation publication, all about vexatious litigation. What is vexatious litigation? Is it clearly defined, actually?
That's a very good question, Sally. I think it really does depend on context. So one would not automatically and easily identify something as vexatious, but as the court case moves forward, it becomes clear that whatever legal arguments are being put on the table are frivolous, have no merit, those kinds of things, that there is a motive behind what is happening. So I think, well, when we're talking about the 2 people you've mentioned, the former public protector and the former president, it was very clear that they had motive and that there was not much merit in what they were doing. So it was a kind of a stalling tactic, what we call the Stalingrad defense. In the Second World War, Russia kept Germany stuck in Stalingrad for 5 months, and the war was won that way, which was a good outcome. But here, the Stalingrad defense has been used by Advocate Mkhwebane for more than a year, and by former President Zuma for about 19 years.
Yeah, I mean, this is the thing, because on the one hand, it seems the courts have been unable to stop Jacob Zuma delaying this case for some 19 years. He, of course, argues that he has a right to appeal. He argues the courts are biased against him and that he actually does want his day in court. So is it difficult to define that line between someone exercising their legal rights and someone actually deliberately delaying a court process? Because the arguments from the other side will be, these are my rights.
Yes, it's actually, I think it's an abuse of the Constitution to a large extent, because the rich, the elites, as you were saying earlier, who have a lot of money, will be able to just keep claiming these rights until the cows come home. The rights in the Bill of Rights weren't written for powerful politicians. They were written to protect South Africans. And so, and what is ironic is former President Zuma keeps saying, I want my day in court, but I don't trust the courts. So why would one want one's day in court if one doesn't trust the courts? And there's been a lot of attacking of the courts going on for a few years now, and it seems to be paying off, which is very problematic. It seems as if courts have become more deferent because, if a decision doesn't go someone's way, then, the law is terrible, the Constitution is rubbish. And it's not a very good situation because it affects the integrity of the justice system, of the judiciary, of people's trust in the courts. So I think what's happening is very vexatious in many ways, and not only in the sense of the court cases.
And you write not only about rich and powerful clients, but also about their lawyers who are prepared to defend them no matter what. We did hear this term quite a lot last week in the one Zuma case, abuse of court process, and I think it was Dali Mpofu who was slammed by the court. Do our lawyers also have a case to answer, or perhaps should I rather say the Legal Practice Council, which I would imagine monitors their behaviour?
Yes. The Legal Practice Council is supposed to monitor their behavior, but currently nothing is being done. It's clear that delaying tactics are being used. The courts are actually saying it themselves. The courts are pointing out that they are being misled, which is actually really problematic. But the Legal Practice Council is dead quiet. And I know Judge Cameron, for example, has mentioned that in a radio interview very recently. And there are other ways in which lawyers can be held to account. So I think one of the things that could be done is personal cost orders. So if a lawyer misbehaves and pushes the court and misleads the court, the legal practitioner, him or herself, could have costs taken out of their own pockets. And I think that will make them, perhaps it will make them think twice about the kind of tactics that they use. And it's very clear to see when they're being used. It's difficult to describe. But, you know, once you see it, you see it.
It's a tough one, because then that lawyer can very easily say, look, I'm being targeted because I'm doing something that the courts, which are biased, do not like. You also believe there's a role for judges to play. The judges need to be calling it more for what it is.
Oh, without a doubt. Look, I mean, we have a good court system in this country, and we generally have excellent judiciary. And I think that judges should become more confident and become more savvy about what's going on and call it out for what it is, because it's easy enough to prove. There are reasonable ways in which to call out these kinds of things. And to use objectivity to expose what is happening. So I do think that judges need to sort of put their foot down in order to protect the integrity of the judiciary. I mean, you know, attacking the courts and saying that they're biased shouldn't lead to a situation where the court system collapses because a few powerful people feel that it's not serving their interests.
And of course, a lot of it does boil down to money. You've mentioned punitive cost orders. In fact, I think I was speaking to Professor Mia Swart last week, and she was saying she was surprised that punitive cost orders were not put in place around the Zuma case. It was just, I think, the typical cost orders. But you've also spoken about state-funded court action where the state attorney can make a decision. No, we're not going to continue to support this person. So explain to me how that could work.
Well, you know, there are no guidelines. The state attorney's office has no guidelines about what they would be prepared to fund, how much they would be prepared to fund. And they don't have any sort of timelines or anything like that in place. So, of course, you know, if a court says, well, this person deserves legal representation, they can get the most expensive lawyer in town to represent them for years on end. So there really does need to be some guidelines put in place so that we're not in this situation continuously where nobody knows where to draw the line. The line must be drawn somewhere.
Indeed. We've dealt a lot with sort of highly politicized cases with powerful people, but we have to talk about these slap cases, which my understanding is when you've got like a big multinational that has a lot of money at its disposal and a lot of lawyers going against some lowly journalist, some small publication or some NGO that's trying to point out an injustice. And they just keep threatening them and suing them until that poor person just has to withdraw or concede in some way. Does that happen a lot in South Africa? Are we clamping down on that really unfair form of litigation?
You know, I think that former President Zuma has brought this into the public eye, very much so, with his private prosecutions that you were speaking about earlier. I don't think it's a common practice in South Africa. It is a common practice elsewhere in the world, to the extent that the European Parliament, for example, is putting legislation in place to regulate this kind of litigation, because what it does is it silences dissident voices. You know, if you have that kind of power and that kind of money, you can just put people in a courtroom and you can stress them. You can, you know, their finances could be leaked out, and you just carry on with your life. And it is a very dangerous thing. And I think that we do need legislation in South Africa to deal with these cases, to limit the cases, to provide defenses, and not to allow these cases to run on for too long, because they're very expensive. And I think that the cases did run on too long. The ones that were in court recently, and I think the judge should have dealt with them in a little bit of a more, how can one say, stern manner, because it was clear that that was what was happening.
Yeah, it's very interesting what you're saying, because on a number of points, what you're saying really is that there are either no clearly defined rules, or bodies like the Legal Practice Council or the State Attorney either don't have the guidelines or are not following the guidelines. And of course, this is all delaying justice and often costing a great deal of taxpayers' money. Thank you so much for chatting to us this evening. That's Narnia Bohler-Muller of the Human Sciences Research Council. Now let's move